for the Tribunal to invite the Crown to to consider and advise the Tribunal whether its position has changed, and to advise the Tribunal as it is able to do so. And that does actually give the chance for the Crown just to take some genuine reflection of these matters and not be rushed by some arbitrary deadline. So the understanding would have to be that will take some time.
Yes.
What would be good, I find myself almost pinching myself and halfway agreeing with Mr. Irwin in terms of the setting the deadline. But if the Tribunal could ask for an intimation from the Crown, then that would assist us in planning for replies and planning for the wind-up of this inquiry. If the Crown does come back and say that it does not want to reconsider its approach, well then the status quo remains. The message from Professor Patuhoepa was that it seems that the Crown submissions are based on national policy and that might be changing in those. But I agree that if this Tribunal sets a deadline that can't be met given the real factors that Mr. Irwin has raised, then that might not necessarily be helpful as well. But we do need a constructive way to bring this inquiry to an end where we can actually see what the current Crown position is moving forward and whether or not it's going to shift in terms of the starting point that was highlighted at the beginning of this week.
Thank you, Mr. Poe. We'll take that into consideration. Mr. Irwin, anything further?
Nothing further on that matter.
Any other matters from Council? Timetabling for today, Mr. Irwin.
So I will continue with the issue 14 submission, and then my learned friend Ms Smith will go through the issue 13 submission. We have 2 sessions available to us, yes. And I understand there is a need to bring matters to a conclusion at the end of the second session at 12:30. Now, I've taken on board, of course, 2 memoranda filed in respect of the Crown's presentation of its submissions, particularly as I understood it, it concerned the whangarei issues, which I think in particular issues, is it just issue 15 or issue 15 and 16?
15, yes.
I think it's particularly issue 15. And I did want to make the comment very briefly that I do take some issue with a party in an inquiry on the one hand acknowledging that it is for another party to decide how it presents its case, but nevertheless to request that the case be presented in a certain way. This week is the Crown's opportunity to really highlight to the Tribunal the key submissions it wants to discuss with the Tribunal, and of course for the Tribunal to discuss the key issues it wants to with the Crown. And we can't go through everything, it's a given. And I've really wanted to spend some time on issue 14 in particular for that reason, because the issues for the Crown are really important. So I suggest we do see how we go, and I do want there to be sufficient time to complete 14, to give genuine attention to issue 13, and then we'll see how we go. It looks like there will be time, and even if the issues 15 and 16 submissions are quickly presented, it may be the case that we will just have to have questions in writing.
Thank you.
So I'm in my document 3.3.415, and we're talking about Te Reo Māori, and last night, by the end of yesterday, we came to my page 32, and we came to the 1930s. And so all the evidence we'd had up to this point that we've looked at has shown that in this area, Te Reo Māori appears to be alive amongst Northern Māori. But a change does happen, and it's from the 1930s onwards. And so I'm at my paragraph 93. During the 1930s and 40s, there appears to have been a nationwide decline in the use of Te Reo Māori. by 1950, so by the end of these 2 decades, a survey of 14,000 Māori children attending state and mission Māori primary schools showed that of 14,000 students, 7,700, so that's just over a half, spoke some Māori at home. 3,000, well, if I take you to the statistics below, about a quarter understood but did not speak Māori, and about 20%, 21% in fact, did not speak or understand Māori. And so that indicates a nationwide change.
Morena, Mr. Ruan. I just noticed that we've got figures here from 1921 on page 32 in terms of those who were speaking Māori at home. And am I right, we seem to have a bit of a jump through till 1950?
Yes.
Is there anything that sheds light on that, what's obviously quite a crucial period?
Not that I'm aware of. I will take you through the evidence that I understand there is. I've really tried to look at when can we really say this change is happening, and it appears from the evidence that it's at this time. And so I will try to take you through that. I don't have, for example, and I don't think the Tribunal has specific figures through the 1930s and 40s. For instance, the tables that I drew the Tribunal's attention to, I don't think we have the equivalent of those for whatever reason in the 1930s and 40s. And it's a shame because we can't, it would be nice, we'd be able to see.
It would be very helpful.
Yeah. So yesterday I had taken the Tribunal to an extract from the Te Reo Māori report, and in the middle of that quote, it said in 1953 the percentage had dropped 26%, and by that they mean by 1953 Māori children who could speak Māori had dropped to 26%. And then 20 years later after that, so 1975, things had fallen to less than 5%. The source for the 1953 percentage was taken from 277 new entrants at 4 Auckland schools outside of this inquiry district. And the Crown does make the point that figure does conflict with the 1950 survey of 14,000 Māori children that indicated approximately 54% of Māori children spoke some Māori at home. So those 2 figures don't seem to relate. And I think the point is I'd really be cautious with the 1953 survey. I think I took Dr. Barrington through that, or might have been Mr. Sterling, but it's just based on one teacher at. I think it was one teacher, although it's from 4 different schools, but it's really quite limited. And I think whilst there's definitely a change, the other survey, it just caught so many more people and seems to be a better survey. So I say it's not precisely clear what caused the decline in use of Te Reo Māori by Māori during the 1930s and 40s, in saying that the Crown accepts its policy of promoting the English language and discouraging Te Reo and native schools would have contributed to the decline. Other factors would likely have included the increase in mixed marriages between Māori and non-Māori, which rose nationally from 1% in 1910 to 12% in 1960. and the population shift of rural Māori to urban areas. Dr. Barrington agreed with that the former would probably have contributed and agreed the latter did contribute to a decrease in the use of te reo in homes. Another factor would have been the desire of Māori parents that their children be raised with English as their first language. It was at this stage, 1925 to 1950, that the Tribunal in the Te Reo Māori report noted a change in attitude of Māori parents. Many now chose to raise their children to speak English as a first language. Undoubtedly, many considered their children would have a better chance of success in an ever-changing world by having English as their first language. Just going down to paragraph 99, evidence from claimants in this inquiry who grew up in the 1930s and 40s is mixed in this regard. And if I may, I would like to just quickly go through this evidence. Mr. Tokai Puritia Wiramu, who was born in 1928 and brought up by his grandparents at Te Ngaere Whangaroa. Mr. Wiramu was clearly a fluent speaker of te reo and would have attended school in the 1930s. He said he wasn't allowed to speak Māori at school and was whipped with a supple-jack if caught doing so. He did say children were encouraged to participate in cultural activities such as kapahaka. He said, nevertheless, I did enjoy school and we had some good German teachers. Mrs. Anitai Uru Martin of Uriuhua was born in 1932 at Lake Mapere. She attended Kaikohe Native School during the 1930s to the early to mid-1940s. And she says, we really enjoyed school. At school we were taught English, science, music and dance, and I really enjoyed it when we got to do some Māori cultural learning. I was not taught te reo. I only learned to speak Māori because my stepmother couldn't speak English, so I had to learn to communicate with her. Mr. Karei Tiatua, born in 1934 in Waimate North, where he was raised. He attended Te Ahuahu Native School, and when it was closed, he went to Waimate North Primary School and later attended Northland College. He says mum and dad were bilingual. They both graduated from primary school. At home we spoke Māori, but when the rest of my brothers and sisters arrived, we mostly spoke English. But we could all speak Māori, even my kids. It was difficult going to school because we had to drop our Māori and only speak English. Sometimes I forgot. I was a bit lucky because mum and dad spoke English and Māori, so I understood English before I started at school. I call this part of speaking English playing Pākehā. Mr. Tiatua says he was strapped at Te Ahuahu Native School for silly things like accidentally slamming the door or for fighting. He thought strapping was draconian. And so corporal punishment was occurring not just, of course, for speaking te reo, but for other reasons as well. Mrs. Moana Nui Akiwa Woods was born in 1942, grew up in Taupo Bay, Whangaroa, educated St Joseph's Catholic School and Kaiō District High School. And she says her father fostered her love for te reo Māori, and that during this time everyone spoke te reo in the parks, the schools, the streets and the markets. Te reo was commonplace, which is intriguing, isn't it? This is the early to mid-1940s, and where she's living, te reo was commonplace. It was not choosing to speak te reo, but it was normal, she says. And by this time, she clarified that she meant the 1940s and 50s, so that's the time period we're talking about. And she says that by the 1950s, she found te reo started to diminish. Mr. Anaru Kiwa, he grew up in the 40s and 50s in Whangaroa, Matauri Bay. He said he was brought up by his grandparents who insisted he speak te reo in the home and chastised him when he spoke English, the poor fella. Coming home from school, he said the whole community at that time spoke Māori, and I seem to recall he clarified in his evidence that he wasn't punished for speaking te reo at school, I think, because he didn't speak. David Samuel's evidence. He attended Whakarara Native School at Matauri Bay in the 40s, and he was punished with a supple-jack. He says that humiliated him. And he gave his evidence about... part of his punishment was he had to go and get the supple-jack. and bring it back. There's an interesting book that the Tribunal should pay attention to, A Civilising Mission, Perceptions and Representations of the Native School System. And it has a nationwide focus, but but the authors have interviewed a large number of people about their experiences being schooled in native schools, and it includes references to many people from Northland, but understandably the interviewees have been kept anonymous, but there are some extracts from the book that relates to Northland Māori that I've included in the written submission, but they tend to corroborate in my submission the variance of what's happening here. People are being punished for speaking Māori, some people are not.
But don't the statistics tell us that overall it was not a very positive experience for most people, given the decline in the use of te reo Māori?
Well, I don't know that the statistics necessarily tell us that conclusion. The evidence that we've received is mixed. That's I guess that's the point I'm making.
Yes.
Some people are saying I enjoyed school, some people are saying I hated it. But the consistent message the evidence is telling us is most people are saying we were not speaking Māori in native schools. And you have a lot of evidence from people saying I was punished for speaking it.
And in that book you refer to, Jamie Bellich talks about that exact issue too between the 1930s and 1940s.
I'm not quite sure of...
Especially in the 1930s and 40s, pupils in some schools were physically punished for speaking Māori.
Sorry, where are you, Your Honour?
Oh, talking about the book you referred to, Civilising Mission?
Yes, by Judith
Smith,
Simon
yes.
and Linda Tuhiwai Smith.
Yes.
Yeah. Just perhaps moving on, my paragraph 110, some extracts from that book indicate Northland parents wanted their children only to speak English at native schools, and I set out some quotes there. My paragraph 111, evidence from Northland claimants who were schooled in the 1950s seemed reasonably consistent with those schooled in the 1940s. Mr. No Epiha attended Te Ti native school in the 50s. He says te reo was not spoken at the school. He does say that he had 3 Māori teachers. Rawiri Timoti, born in 1948 and started at Matangiro native school when he was 5, says he was not allowed to speak te reo even though it was his first language. He says he was punished for speaking it, including having to spend an hour after school pulling grass from the courts and digging drains. Mrs. Patricia Tauroa says she began school at Otangaroa native school at the age of 5. She says she later attended Kaiō primary school in 1950, which means she attended Otangaroa native school at some point during the 40s. And while she was not punished at the native school for speaking te reo, she says others were. She does, however, say in her evidence, and I thought she really was wanting to make that point, that the native school did provide her a good education. Mrs. Kawhena Paul, born in 1949 in Te Ngaire, Whangaroa, says her parents never taught her te reo, says she always thought this was because her parents thought English would lead her to higher achievement. She also thinks, but she did say she didn't know for sure, that this could have been because her parents didn't want their children to be punished at school for speaking Māori. Mr. Karena Rameka of Ngāti Ue One One, Ngāti Tautahi, Ngāti Whakaeke and Matarahurahu was born in 1951 and was brought up by his grandmother. He attended Kaikohe Primary School. He says everyone called it the Kaikohe Pākehā School. His other siblings all attended the Kaikohe Native School. Mr. Rameka says that in Standard 2 or 3, when he was playing netball and he called out, Pānga mai ki konei, throw at the ball here, He was told by the Māori teacher that he wasn't allowed to speak Māori at school. He does not translate his reply to the teacher. Poko kohua e tau reka reka. But he does say he was beaten for it. Mr. Rameka also said that despite going to a Pākehā school, and this is intriguing, he spoke better Māori than his siblings who attended a Māori school. Mr. William Hori was born in 1956 and started Kaiō Primary School in 1961, and he recalled the strap being used once, but heard about somebody else getting caned at college almost daily. He says te reo was never spoken or promoted at school other than when we sang some of the familiar waiata in the singing class. He says his father and mother spoke te reo at home to themselves, but did not speak te reo to their children. He says his dad said, "You have no need to speak te reo because we live in a Pākehā world." And so experiences were varied. There were some positive aspects to the native schooling education. There were some examples of Māori parents who were capable in te reo, deliberately choosing not to speak te reo to their children. There were experiences of some punishment for the speaking of te reo. And near the end of the section on te reo, the Crown is, however, unaware of evidence that punishments for speaking te reo in Northland native schools was brought to the Crown's attention. As is clear from the above submissions, the practice of punishing students for speaking te reo was against Crown policy. In those circumstances, the Crown's position is that the Crown did not breach the principles of the treaty and its policies regarding punishment for speaking te reo Māori in schools.
Can I just stop you there, Mr. Irwin? Do you think that lack of awareness is because, as you yourself have pointed out, corporal punishment was, I mean, it's not like today, is it? I mean, people were regularly strapped for a variety of reasons. So is that part of the explanation?
I guess so. I mean, for the Crown, I mean, if we look at this in terms of in treaty terms, and we're trying to look at, well, at what point was the Crown made aware that its policy, and its policy is don't punish children for speaking Māori, but there is tolerance not only within the community at large, but also in the education system of some form of corporal punishment for other things, for misbehaving. At what point can we identify that the Crown was made aware that that your policy is not being applied correctly by teachers? And the problem is, I cannot identify that. So, for example, we have evidence of the logbooks that the native school masters were required to keep, and we went through some of those logbooks. I recall at one of the hearings, and I did not actually see a record of a child being punished for speaking te reo Māori, and I guess one would not expect to see it. I mean, the evidence shows children were getting punished for speaking te reo. The Crown's policy was don't punish students for speaking te reo, and so I guess we would not expect to see teachers recording their breach of the Crown's policy. And so the Crown says it's very difficult for the Crown to say that it's breached treaty principles because it has a policy saying one thing. The teachers might be doing at times another thing.
Because it is, I mean, I struggle with it because then you have to ask, and I take your point of lack of awareness, and whether it's just kind of accepted practice within the education department at a practical, on the ground, if you like, in the schoolyard, and the disjunction between policy and practice that we've come across before. And then what is the responsibility of the Crown for the actions of its servants?
Yes.
And so, do you have a comment on that?
Yes, I do.
Yes.
It really is probably the same comment I've made, because it would be very different if the native school codes that we went through, and we've gone through in such detail, if there was a sentence in there that said you should punish children, however, physically or otherwise, when they speak te reo, you should only use the English language. There should be a full immersion of English, absolutely. Now, it would be a very different story if that was in the Crown's policy, but it's not.
But back to my question, if we accept the policy but the practice is different,
Yes.
then does the Crown have a responsibility for the practice of people who are employees of a government department?
Well, yes, to a degree though,
Yes.
but what is within the Crown's control is setting its policy and its expectations, and that is why I made the point about the Crown's awareness. There is no point of time that I can point to, or I just can't see the evidence that shows the Crown was made aware of what its employees were doing. Now, if there is evidence to show that complaints were being made to whoever really, that children were being punished for speaking te reo Māori, that's a different story. But again, I haven't identified that.
And we get back to this problem that possibly it's just people accept it as one of those things that goes on, and so complaints aren't likely to surface.
Well, yes, and I mean there are two other factors. One is probably a general acceptance within the community, or maybe a general acceptance is too strong a term, but there's a different attitude, that's certainly the case, of the community generally towards corporal punishment in schools. And today we see things very differently. So that's a part of it, because if there is a different attitude towards just the issue of corporal punishment, then it might have been the case that parents weren't going to complain for that reason. And of course, there's the other point too, that the evidence does show that a lot of Māori parents had taken a different attitude towards the Māori language at that time, and the importance of their children to learn the English language only. So again, there's that factor as well.
And I suppose, speaking from my own experience of growing up, if parents have an issue with something that a school teacher does, they take it to the school teacher, don't they? They don't take it to the government department.
Yes. And I seem to recall, I can't remember exactly what the issue was, but I seem to recall we have had evidence of that in this inquiry, of parents going directly to school teachers. I just can't remember what the exact issue was.
I think it was a corporal punishment issue for te reo speaking. All right, thank you.
But it doesn't stop there, because the Crown has some responsibility here. And I come to my paragraph 114. The Crown accepts that capabilities in te reo declined over the 20th century in Northland. Nationwide, the Crown understands that by the 2013 census, only 21.3% of Māori could hold a conversation about everyday things in te reo Māori. This is in marked contrast to the position Northland Māori were in as at 1920. And when I say, I say rather starkly, 96.7% spoke Māori at home. Of course, what I mean is that from the data we had, 96.7% of Māori children in native schools spoke Māori at home. But it's indicative, isn't it, of there's been a serious decline. While the Crown is not solely responsible for the Crown accepts it has a treaty duty to actively protect te reo Māori, and once te reo began to decline, the Crown had a duty to intervene. The Crown concedes that it failed to actively protect te reo and encourage its use by iwi and Māori, which had a detrimental impact on te reo Māori in Northland, and this was a breach of the Treaty of Waitangi and its principles. The current day situation is what I come to next.
Mr. Irwin, sorry, could
Yes.
I just ask a couple of questions there? So I'm not quite sure from what you said when, as far as has the Crown considered when the decline of te reo began and over what period so that you come out the other end with the 21.3% by 2013. But over what period does the Crown consider that change was happening?
From the 1930s onwards.
From the 1930s. And you're saying, is it the case from the various kōrero that you've reproduced that punishment for speaking te reo, the evidence is from kaumātua kuia who were at school in the 1940s and 50s?
Yes.
Yes. Yes, just going back to what you were talking about very briefly with Dr. Anderson, I do find it a little hard to sort of get my head around the fact that if punishment for speaking te reo was as widespread as the evidence we've had suggests in small communities, and New Zealand is a very small place, particularly back then, that in fact Crown officials through their various networks remained unaware of what was going on.
I can't take the point any further than I think I have with Dr. Anderson.
And again, you've talked about the fact that we get to a period where parents are deciding to speak to their children in English rather than in te reo. How far is that because, in fact, te reo was so little valued in the wider society at that time? It was a very monolingual society, and as some families were moving into urban areas, that probably was increasingly the case, but there seem to be examples also where this was happening in the rural communities.
I'm only speculating. If I were to really answer the question, as I understood it from the evidence, the evidence suggested that the attitudinal shift was because Māori parents wanted their children to get a better chance in life, and so we start to speculate then, although probably with reason, as to what's motivating them. Why is it that English is going to help them to get a better chance in life? Presumably it's going to assist with employment in particular.
Yes.
That's a fair inference to draw. But it becomes an issue of society, doesn't it? At a given point in time, what is society's attitudes towards something like the language that is spoken in the workplace? And there are only certain things that the Crown has control of. But in saying that, the Crown does recognise that it had a duty here, and it did fail to encourage as much as it failed to promote the language. Yes. And it needed to do that, and it didn't. So.
Kia ora. And just finally on that point, the Crown has acknowledged now the detrimental impact on te reo in Northland of its failure to protect the reo. But there was also, from what we have heard over many months, a detrimental effect on many children over a number of years, for whom school became a distressing and scarring experience Does the Crown acknowledge that as well?
No, so my statements are quite careful. I have the instruction to make that acknowledgement and statement, and that's the acknowledgement or the concession that the Crown's made in terms of treaty breach, and possibly.
So it's in terms of te reo, not in terms of the detrimental impact on the people.
Yes. Well, no. I was just going to say.
I suppose it comes back to what I was asking yesterday about what's the extent of that concession.
Yeah. I have to keep to what the Crown has said, and so that is the Crown's concession. I can't start extending it. It's difficult for me to just go further than what's there.
So the detrimental impact on te reo Māori, is that te reo Māori seen as a taonga
Yes.
in terms of Article 2?
Yes.
But that doesn't that's not recognising the detrimental effect that it had to the people.
Well, well, I think it. I mean, I think I'm still within this concession to say I think that is. I mean, kei te ki etahi ko te reo te hā o te Māoritanga, and if that's the case, the Māori language is the life breath, if you like, of Māori society or Māori dim or Māori tanga, however you translate that. I mean, if that's the case, then for the language to diminish, the people are necessarily impacted in a detrimental way and in breach of the treaty. So that is acknowledged. I think that's within the concession. I come to the current day situation. And I say it in my paragraph 115, more recently things have changed for the better. Now I'm not going to go through the detail of this. It's there for the Tribunal, and you've taken this into account. There's evidence from the Ministry of Education that noted that the work of the Ministry and Education sector agencies is underpinned by the Māori language in education strategy, tau mai te reo. So there is a specific strategy within the education sector that deals with the Māori language. And there's a focus there on working with and for iwi communities and Māori language providers to strengthen the Māori language in education. And so it's not just an issue of providing Māori teachers or teachers with a capability to teach te reo Māori. It's much more than that, the Ministry of Education says, and its evidence on that was fairly clear. Paragraph 117, this strategy, along with the strategy ka hikitia, highlights the importance of the contribution of whānau and iwi to the educational success of Māori students. In addition to tau mai te reo, a number of Māori language strategies have been developed by individual iwi reflecting their goals and aspirations in mātauranga. And there's further submissions on the issue 13 issue about this. And quite importantly, we have a new law called Te Ture mō te reo Māori 2016. Now, I referred to an interchange between Your Honour and Claimant Counsel concerning te reo Māori. And Claimant Counsel said it was an answer to a question about the Crown's financing of reviving te reo. Claimant Counsel acknowledged that the Crown's finance alone would not revive te reo, and acknowledged that the fate of te reo is in the hands of Māori. And I set out the quote there. But it's interesting. E kiana, when e kaikare me, e kiana nā hapu o ngā pohi, kei a tātou te mana whakahaere, kei a tātou anō, wā tātou tākuta e ora ai i a tātou reo, no reira, ko te tūranga o te karauna he tautoko noa, he tautoko mā te pūtea ki te hāpai i ngā whainga mātua i ngā wawata noa o te hunga Māori o te raki. Kia kaua te karauna e nāna ki te whakahaere i aua haipapa i aua mea rā, me waiho mā te iwi Māori, nā te mea e mōhio ana tātou katoa, ko tō tātou reo me pēhia a tātou e hiki. And the Crown submits that the recently enacted Te Ture Mō Te Reo Māori provides for these matters. The Crown notes that Claimant Council, at least in the submissions, I don't think I'm aware of submissions from my learned friends about Te Ture Mō Te Reo Māori 2016. Te Ture Mō Te Reo Māori 2016 specifically recognises the Māori language as a taonga of iwi and Māori, and that iwi and Māori are the kaitiaki of the Māori language. It is an act that is written in both Te Reo Māori and English. The Act provides that the Māori and English versions of the Act are of equal authority, but in the event of a conflict in meaning between the two versions, the Māori version prevails. The purpose of the Act is set out there, and there's also an important acknowledgement in section 6 of the Act. I don't think I need to read that out, but the Crown has acknowledged in that section the detrimental effects of its past policies and practices that have over the generations failed actively to protect and promote the Māori language and encourage its use by iwi and Māori. And the Crown has expressed its commitment to work in partnership with iwi and Māori to continue actively to protect and promote this taonga, the Māori language, for future generations. And importantly, the Act establishes certain things to make this happen. It establishes Te Mātāwai, a new independent statutory entity which will provide leadership on behalf of iwi and Māori in their role as kaitiaki of the Māori language. Te Mātāwai will develop the Maihi Māori language strategy, which will provide objectives and policies for iwi and Māori relevant to the Māori language and supports its revitalisation. The Maihi Karauna will be the Crown strategy for Te Reo Māori and will complement the Maihi Māori. Te Puni Kōkiri, in partnership with Te Taurewhiri i Te Reo Māori, is leading the development of the Maihi Karauna, working with other Crown agencies. Te Mātāwai has 13 members, 7 appointed by 7 iwi clusters, 4 appointed by Reo Tukutuku, those are Māori language stakeholder organisations, such as, for instance, the Māori Women's Welfare League, and only 2 by the Minister for Māori Development. And I set out the functions of Te Mātāwai, which are broad. Over to paragraph 128, Te Mātāwai is funded by the Crown, and I set that out. And those are the submissions of the Crown concerning Te Reo Māori. Any other questions on that?
We can move on to the next section, Mr. Irwin.
So we move on to the section concerning wāhi tapu. Now, the issue of wāhi tapu is an issue that's been addressed in a number of inquiries. It is one of these issues that that comes up again and again. The Tribunal has in other inquiries looked at the legislative regime that relates to the protective mechanisms for wāhi tapu, particularly through the 20th century, coming through to current day legislative protections for wāhi tapu. I address and respond to the claimant generic submissions in respect of those legislative regimes. Just possibly in interests of time, it might be better to focus on the particular case studies, because we had case studies on wāhi tapu, particularly it was the evidence of, it was Mr. Armstrong who had, together with, I think, Dr. O'Malley and Mr. Sterling, presented a report, I think it's A14. So I'll try to move through the section possibly
but
a little more
quickly. Just before you move to that, can you just clarify for me as to what you see the Crown's duty is in terms of wāhi tapu? Because as I read it at 131 and following, yes, the Crown has a duty in terms of wāhi tapu, but not wāhi tapu on Māori land, not on privately owned, because Māori have their own responsibilities for wāhi tapu on Māori land, I presume.
Yes.
Not on privately owned land, and when the location of the wāhi tapu is known, because you can't have a responsibility if you don't know where it is. But so it's limited, and then even then the duty must be weighed or balanced against the interest of others, including private landowners and the community as a whole.
Yes.
Is that my understanding of the duty?
Yeah, I guess so. So the Crown acknowledges and recognises in my paragraph 131 that it has a duty of active protection that may require it to take active steps to protect wāhi tapu, but there are
a number of exemptions.
There are well, I don't know that
limitations.
Limitations to how in practice the Crown can actually do things, and in the biggest, in the broad picture, when land was sold, and I'm going to, the first example I'm going to take you to is a good example of this. There was a need for Māori to identify the wāhi tapu they wanted to protect. And I'll take you to an example where they specifically identified certain wāhi tapu but did not identify and protect others. Sales go through, and the problem for protecting the wāhi tapu now that it's privately owned is difficult. The government must respect the private property rights held by that rights owner, and can only do so much. And the example will actually show that the Crown did try to assist and investigated what could be done, but to a large extent was hamstrung and was not able to force at that point in time at least certain changes. It certainly couldn't force the return of the land. Today's regime is different, and there are different mechanisms available. Today's regime builds in protections so that even wāhi tapu on private land are accorded certain forms of protection in the current day situation through the resource management regime, through district plans. And I can take you to evidence to show you the plans, how they've identified certain wāhi tapu. And the way those regimes operate, of course, is that if somebody, even on private land that's general land, seeks a resource consent to do something, for example, to subdivide, or something not as extreme as that, something like earthworks, where wāhi tapu are identified, they will trigger things within that plan that will require, at the very least, notification to Māori, and will likely result in the imposition of at least certain conditions, such as archaeological surveys, as a condition of consent. So I've taken you through, just in kōrero a vast period of time. That regime didn't operate in the 1920s or earlier.
So
And I guess too, just coming back to the first period of time, when a sale occurs, and it's, for instance in the 19th century, Māori are selling the block. They are ending their ownership and control of that land and giving that to the person who purchases it. And there is a need for sellers to identify and exclude from sale those wāhi tapu they wish to. Sorry, Dr. Anderson.
Oh, sorry. Well, this is the point I was going to ask you about. When you look at that process, aren't we back to your Crown concession about the individualisation, fractionation of title? That in the first round, maybe the urapa was reserved and protected, but as partitions happen, other wāhi tapu end up in the hands of a particular group or an individual, and then it becomes vulnerable.
Yes, I agree. Yes, I have to agree.
All right, thank you. Just a follow-on question on that. Do you think in the 19th century, when people thought about wāhi tapu, they were really thinking about urapa?
I would have thought that would be the main thing that they were thinking about. And by urapa, I'd include burial caves as much as burial grounds. I would have thought that would be the key thing people are thinking about. So, for example, I don't think we're talking about areas that have been subject to tapu. If we go back into the 1820s and 30s, Augustus Earle's book is intriguing, where he, in the 1830s, traverses the east coast of this location to the Hokianga, to the west coast, and during this time, the party stops. A woman from his party eats kumara, I think, from a area that has been tapu'd. She didn't know this, and then when she was informed of this, she goes into a terrible state and dies within, I think, 2 or 3 days. And I haven't seen in the evidence around wāhi tapu in this inquiry that kind of tapu or wāhi tapu being at issue in the latter half of the 19th century.
All right, well, maybe there's some other examples.
Well, I was just going to ask you, did you have other things in mind?
Oh, well, I was thinking of maunga and the loss of those. I don't know whether you include that within wāhi tapu or not, or whether they should be. Maybe it's more a taonga than other.
It's probably, I think if I say anything, I'll get boos from the crowd, and,
Yes.
and probably fairly so. It's probably for the people to say. I would have thought, though, that a maunga isn't necessarily, maunga significant. We can see them up behind us. And, you know, te whare tapu o Ngāpuhi has a particular significance that it attaches to the maunga of Ngāpuhi. But I don't know that they would necessarily say that the maunga are wāhi tapu in that kind of sense. And I don't actually know that the people would say that they're taonga. And I suspect they would say they're maunga, and that includes within it just significance in and of itself.
I suppose that I was a bit worried. Maybe we can come back a bit to it. It's the statement that people were naive to think that they would continue to have access to wāhi tapu or taonga or what have you, and I was a bit worried about that statement. But maybe we'll come back to it when we get to that part of your submission.
I was actually going to move through
Yes.
to the Lake Tauanui example. I think the point being made at my paragraph 142 is the authors of the A14 report who are saying that, put the naivety issue aside, if they're saying Māori when they sold land just assumed their wāhi tapu would be protected, I just don't understand the basis of that assumption. On the contrary, I would have expected, and maybe the Lake Tauanui example will be a good one, I would have expected vendors to retain title to their places of significance, their wāhi tapu, whichever they are, whether they're maunga or urupa or whatever, and to identify them and exclude them and retain ownership to them. If they want them, and it may be the case that really there are different attitudes in the 19th century, it might be the case, there are changes too, aren't there? It was interesting. We had a site visit to, I think, one of the churches, was it at Kerikeri, and it was explained to us there was a shift in the move from placing bones of the deceased in caves, and it was intriguing in Utukura to hear the evidence around the process and the places they went to that bear the names of the actual process that happens with the deceased, on the way to them being placed in a burial cave. And there was a change. I can't remember exactly when it was. Probably happened over time, but there's a change to putting the deceased into cemetery sites, urupa, if you like. And that doesn't mean that those caves are not wanted and aren't considered to be special, and I'm not saying that at all, because the example I'll take you to shows that there was some real concern about one of these caves. But it might be the case that there are changes in attitudes towards wāhi tapu, and I think particularly as Northern Māori are losing more and more and more land, these wāhi tapu become more and more and more important to them.
And maybe also we come back to this problem of what Māori understood to be happening when they're transacting land, and what the long-term implications of it are, or indeed, because we've looked at, especially in that early period, that
I think in the very early period, by that I mean, say, the pre-1840 period.
Yes, and and I think that, I guess I can't really. Well, Claimant Council would extend that period a lot further.
Yes,
and I suppose this is an issue that we as a tribunal are going to have to decide. There does seem to me some ambiguity, certainly in a lot of those earlier Crown purchases, as to exactly what was what was happening, or indeed whether people even knew it was happening. So,
Well, and that comes back to your issue, and my issue,
yes.
individualisation of title, of course.
Yes.
Because that is what makes these things so much more vulnerable. And as time goes by, makes it even more vulnerable. And then I think you have the general community, general Māori community, the hapu, for instance, who are in a position, say, you know, as it progresses through the 20th century, of not being the owners of, say, individual lands, but as a hapu, they say, these are our ancestral lands. And the individual owners might have decided, we're happy for whatever reason that we'll sell the land, and it might include a wāhi tapu. But the broader hapu are saying, but as a hapu, we have associations with that, and we lose more and more control if you alienate that land. And so that's unravelling from the issue of individualisation of title.
Yes. All right, thank you.
Well, perhaps we could look at a particular example, Lake Tauanui. I was going to take the tribunal through, I just see my notes, I was going to take the tribunal through some of the evidence of the current day district plans. Perhaps if I just refer the tribunal to the evidence. But in Z6A, there are extracts from plans that relate to this area from the Auckland Council's plan, from the Far North District Council plan, and from the Whangarei District Council plan, and there are the lists of sites of significance in wāhi tapu that have been identified, just to very quickly make perhaps a couple of points. Those lists rely on you people identifying these, working with councils to make sure these places are identified. The second point is they can be identified in quite a sensitive way. As those lists show, there are certain things called silent files, where in a broad sense the wāhi tapu is identified but not its specific location, so that because it's noted that there is a concern of identifying what is really special knowledge of the people, and so that's a way in which that happens, and there are examples on those lists of certain silent files in this inquiry district. I was going to take you there, but I just in the interest of time won't.
When do those provision for those silent files date from, Mr. Irwin?
Well, I'm not sure. I'm not sure, but the plan from memory was dated 2013, I think. So at least by that point. I'm sorry, Dr. Parsonson, I'm not quite sure when that issue was, the ability to do that was, came into being.
And are you aware whether that it was quite widespread that people then took advantage of that provision?
No, I'd be giving evidence from the bar if I made a comment about that. I genuinely don't know the answer to the question.
Thank
you. I want to take the tribunal to page 67 of my document. This concerns Lake Tauanui and the motu Harangi Urupa or motu Whārangi Urupa. And if possible, I'd like to bring up on the screen a map from R20. It's one of the first pages of R20, and think it might just help to, and it gives us a bit of a change of scene to see a picture. But I want to make a point with the picture. So we're in R20. If we just come back a few pages, I think, just after the index at the start to what would be page 4. There's hopefully a colour map. And still going back. And still coming back. And just pausing here, coming possibly just up a little, just a fraction. There we are. Now, difficult to see, but in the middle of that screen, you should be able to see a lake. This is part of a plan for Motato. Now, in 1911, interests of a number of owners in the Motato number 5 block were purchased by a Pākehā person, and at this time, as I understand it, the Motato number 5 block was partitioned into a number of partitions. There were quite a number of owners. The interests of the Māori owners who had sold in the Motato 5 block were placed into the 5G block. And what we're looking at, you'll see right in the middle 5G. And that includes that lake. And the Lake Tauanui was also known as Kereru. And there's an island on the lake called Motuharangi, and I've seen reference to Motuwharangi as well. Now, there was a burial cave on the island and the lake. At the same hearing, Motato 5D block was created, and it included 3 wāhi tapu reserves. Now, we can actually, depending on your eyesight, you can see the lake. There's a small peninsula that juts out in the middle of that lake, and there is on the plan, if you can see it, a rectangle identified, and the words say wāhi tapu wharehuinga, I think. And that was an urupā, not a burial cave. And it was identified and it was excluded from 5G. Now, it's difficult to see in the picture, and please don't move the picture on the screen, but just if we start at the lake to the, if you go in a diagonal to the top right from the lake, sort of to about 1 o'clock, there is another wāhi tapu, which is the plan states as part of 5D. So it's identified, and it's called wāhi tapu manawa here. Now, I'm not going to take you there. I'll just do this quickly. I don't think I can see it on this map, and it is if you want to take the time. Just a few pages over, but I don't think we need to move the screen. You'll see there's another wāhi tapu which is identified on the plan for 5D. It's in the exact opposite direction, going, if you like, to about 8 o'clock from the lake, on a slight diagonal to the left and down a little. So 3 wāhi tapu are specifically identified. No, that's fine, thanks. They're specifically identified and excluded from the sale because the sale block is 5G. Mr Armstrong agreed in cross-examination that it was possible different hapu or whānau used different burial sites, because it is intriguing that within this area of land we have 4 burial sites, 3 urupa it appears, and the burial cave. But he agreed that it was possible different hapu or whānau had used different burial sites and that the burial cave on the island was not necessarily used by all of the Motato 5 owners. Mr Armstrong also agreed it was possible that the non-sellers believed their wāhi tapu had been protected because they had included in the 5D block wāhi tapu and the burial site on the island belonged to the sellers. In 1922, so this is 11 years after the sale, Māori forwarded a petition requesting the lake and the island be returned to them, stating that burials had taken place on Motu Whārangi and the adjacent Wharehuenga Urupa. The petition stated that Pākehā had removed remains from both sites and they had been caught doing so on Motu Whārangi. The Native Department acted in response. It asked the Registrar of the Tokero Native Land Court to undertake an investigation, and he in turn consulted Blomfield, who had represented both the buyers and sellers at the petition hearing in 1911, 1911, with Judge McCormick, who had presided at the hearing. The Registrar was told by Judge McCormick there had been no reference to the lake during the hearing. The Registrar's report was then forwarded to the Native Affairs Committee, and in 1924 the Native Affairs Select Committee recommended that the Chief Judge undertake an inquiry. Now, Mr Armstrong's part of the A14 report only took matters so far. He said there was no indication that an inquiry had taken place, and we put to him documents in the R20 document bank that showed that, and Mr Armstrong agreed, an inquiry had taken place. And during that inquiry, it was said by Blomfield that Kuao's party did not ask for the lake to be reserved and they did not mention it was tapu. Judge McCormick said that had they mentioned it, he would have reserved it as he had done with Motato 5D. He noted there were no appeals following the decision, and Judge McCormick also said that he had talked to Blomfield, who had said that he pressed Kuao, who was one of the people involved, to include the lake within Motato 5E, which Kuao owned and which was near the lake, but Kuao ignored his advice. Judge McCormick said that the Pākehā owners of 5G had indefeasible title and the former owners would therefore have to negotiate with them. Minutes of the inquiry that took place indicate the former owners understood they'd sold the lake and the wāhi tapu, that the wāhi tapu would be protected if it was reserved by the Crown, and that by obtaining the agreement of the landowners, the site could be further protected. The minutes state, we want to get our lake and tapu back, we would give land for it. If that cannot be done, we'd like the government to make it a reserve so that our dead may be left undisturbed. And I go on to make some other comments in respect of this example. And I'll just come to a quote from Dr. Clayworth. Is it Dr. Clayworth or Mr. Clayworth? Doctor, thank you. Dr. Clayworth, his report is A65 at my page 70. He says the Lake Kereru case, so I take him to be referring to this case as well, shows that some protections did exist for wāhi tapu, as shown by the fact that the Motato 5 landowners were able to get 3 wāhi tapu areas set aside in Motato 5D. It appears, however, that if owners failed to raise the issue of particular wāhi tapu such as Lake Kereru at title or petition hearings, it became very difficult to protect such areas if ownership passed to Pākehā. Just coming down to my paragraph 214, the site does not appear on the New Zealand Heritage List. It does, however, appear importantly on the schedule of sites of cultural significance to Māori in the Far North District Plan, which means that activities on the site are restricted under the plan and that tangata whenua are considered to be, are considered to be affected parties under the RMA. And can I just add to my footnote 273, that is an evidence, and so the evidential reference for that footnote is Z6A at page 27. My paragraph 215, this is a case where if Māori alienated wāhi tapu to protect... This is a case where if Māori alienated wāhi tapu to private interests without the knowledge of the Native Land Court, there was little the Crown could do to assist them, except to encourage all parties to negotiate a reasonable solution. The Crown spent considerable effort in its attempts to investigate whether there had been an oversight on its part that resulted in the wāhi tapu being alienated to Pākehā. The conclusion was that there had not. There are mechanisms today which are noted above which do provide some protection for wāhi tapu such as this. There's a similar issue, I guess, comes up in the next case study, the Maruata, and there's a kauri tree there, and I take the Tribunal in the submission through the issues associated with that and the facts around it. I don't want to bring up any more images on the screen, but there was a petition in 1903 which created, amongst other things, Maruata 6D, and that was a small petition created from the Maruata 6 block expressly for a wāhi tapu, which was located in the far corner of the block. And the issue was, I think surrounding land is sold to a farmer, and that's the 6E block, and the issue is a kauri tree, and quite where the kauri tree was located. It appears that there is a burial cave here, or I think it's a burial cave, and the issue was the tree in 6D or 6E, and whether there was a mistake in the survey. And because we had taken Mr. Armstrong and his evidence to be saying that there was some surveying mistake, but I think it was shown that there wasn't a survey error. The surveying just got things right. There was, my paragraph 218, there was no mention of the burial cave or the tapu tree in the minutes of the Native Land Court hearings that are relevant here. They also do not state where the burial cave was located, except they say that a wāhi tapu of half an acre known as 6D was to be located in the northwest corner of the block and was to be awarded to all the owners. And there was no objection when the petitions were created in 1903. In 1940, Māori, including Wiremu-Kake, raised the issue that the burial cave was located below the sacred tree, which was located within 6E. And so this issue was raised again, and complaints were apparently raised because the then owner of 6E wanted to fell the tree. The owner had apparently indicated that the real motive, that there was another motivation going on, but there is evidence that Wiri Kake was able to negotiate the purchase of timber from the tree, which was used to build the Pehi Awiri Marae. My paragraph 223, later, evidence was filed stating the location of the actual burial caves was in the centre of the Marawata 6 block, and that at some time the Kauri tree had been cut down. The Crown notes that this means Marawata 6D Waihi Tapu Reserve was positioned some distance from where the actual burial caves are located, and the owners did not question that when the reserve, if that's the case, they didn't question that at the time the reserve was created in 1903. 226. The Crown submits this is another example where Waihi Tapu passed out of Māori ownership and into private ownership, and where no objection was raised at the time by interested Māori. And I guess the point is Māori were reserving land for Waihi Tapu, but it appears that they were not reserving, in this case they didn't reserve the burial cave from that sale. I thought I might move to the issue of taonga, and possibly just speak broadly to this issue. But before we do,
I just have a couple of questions, arising from about Waihi Tapu still. Back on page 46, you talk about the Crown not being obliged to protect every Waihi Tapu, and that the extent of protection will depend on the relevant circumstances, including the significance of Waihi Tapu, and must be reasonably balanced by the public interest. And can you explain more about the process of deciding what is a significant Waihi Tapu, and also when it comes to balancing a treaty duty against the public interest, how that actually plays out?
Yes, so we'll start with the first question first. How is a significant Waihi Tapu identified? And the Crown says this is an issue for local government and for the people on the ground, as it should be. And so there is a good, proper process that local government go through with tangata whenua to create these lists so that the people themselves can identify what they see as being sites of significance. If we looked at those lists in Z6A, you would see that the list, I think, for the Far North District Council is not a list of Waihi Tapu, but it's a list of sites of significance to Māori, I think it's entitled. So it is what the community say it is, and it requires engagement between, and it's a two-way process between the local authority and the people. I recall at one of our very first Stage 2 hearings, questioning Mr. Arapeta Hamilton, I think it might have been, simply to make the point to everybody who was listening that at that point in time the Far North District Council was going through a review of the lists, and it's always open to hearing from people, about identifying these things. So the Crown says it's for the people, it's for the local government to identify these things. It's for them to say what's significant or not. It's not for the Crown. And then, of course, there's and the submission goes through it. The Crown assists in this through other lists. Again, there's the Heritage New Zealand list, and there's an archaeological focus there, and that assists in helping local government and people to identify sites. And it's got to be acknowledged too that the people don't necessarily know their own sites, and there's a limitation for the people in that regard too. So there's some assistance there that the Crown provides in that regard. So that answers your first question?
Yes, thank you.
And now weighing, coming back to my statement, the very broad statement at paragraph 131, the extent of protection will depend on the relevant circumstances, including the significance of the wāhi tapu, and must be reasonably balanced by other public interest factors. And I think other public interest factors would include private interest factors, wouldn't it? For instance, the rights that private landowners do have and that need to be accorded respect by the government through its laws. So today we have a regime where through local government and through the resource management process, the law provides a form of protection to sites of significance and wāhi tapu on private land. It restricts to an extent what private landowners can do. These trigger mechanisms that are meaningful so that when significant things are happening, such as major earthworks or subdivisions or whatever, that the local people are being consulted and having a say, and that remains, if they're discovered, are being identified and addressed and treated with respect accordingly.
One of the complaints I think the claimants have made or have questioned the effectiveness of those measures and the sort of penalties that have actually been imposed in practice when they're violated. Do you have a comment on that?
Yes, I think it was Mr. Edwards from Heritage New Zealand gave evidence. I included a quote from him, my paragraph 184. And actually just going back to 183, the maximum penalty for destruction is a fine not exceeding $150,000 in certain cases, and $300,000 in other cases, and there are other penalties as well. Mr. Edwards explained in relation to the penalties for modification or destruction of an archaeological site that the wonderful thing is, he said, the person responsible gets a criminal conviction, and so that tends to limit, if someone gets a criminal conviction, it means they can't travel overseas, they can't do stuff. So it's it really is a very good deterrent. So I think the point he's making is that it isn't just the financial penalty, which is the potential liability is relatively significant. But just putting that to one side, his point is it's a conviction at all, and that is a deterrent.
But, and I suppose my point is, have there actually been prosecutions undertaken under that legislation when we know that there have been instances of destruction that claimants have tried to prevent, and nothing seems to, their complaint is, well, nothing seems to happen?
I can't recall off the top of my head, Dr. Anderson. I would just need to check the transcript for the cross-examination of Mr. Edwards about that issue.
All right.
I don't. His brief of evidence was relatively short, and I can't remember if he included anything about that issue. I suspect he did not, but it might be that there was some evidence given in cross-examination about that issue. So my only answer could be what is said in that transcript.
All right, thank you. And just talking about wāhi tapu on Crown-owned land, can the Department of Conservation prevent the public from accessing wāhi tapu?
I don't see any reason why it could not. Are you aware of a reason why the department could not?
No, I think this is one of the allegations that Claimant Council have made.
I did include a section in here concerning the department.
I mean, we know with Kauri, for example, that there's been, which is a different issue, but has some parallels, that there seems to be a lot of difficulty from the reluctance, if you like, from the Department of Conservation of preventing public access. Yes,
if it's in my paragraph 152, and at the end of that paragraph, the department uses a number of measures to deter the public from entering areas containing wāhi tapu, and there are a number of ways in which the department does that, which include really sensible measures like aligning or realigning tracks to lead people away from them, negotiating or acquiring alternative access, establishing and promoting suitable alternative sites for recreational use, providing information, promoting cultural values and encouraging respect for wāhi tapu, discouraging access by explanatory signs, and this is the question you're asking me about, excluding or controlling public access by bylaws or regulations under the Conservation Act. You could look at Z7 at paragraphs 72 to 76 as well, and also paragraph 266.5 more specifically. So yes, the department can, and I think yes, the department does, and it seems to be doing more than just fencing things off, but also positively doing the other things that I just talked about, which is a good thing.
All right, well, I have some points of detail which I might put in writing to you so that we can move on. Okay, thank you very much.
Well, we've come to 10:30. Yes. Can I suggest we do take the break? It may be the case, I'll have a discussion with my learned friend Ms Smith about how we proceed from here, and I'd be happy to talk to Mr Meritor during the break as well. Okay, kia mau tātou. Before we do take the break, I just wanted to outline for people how we think the mihi are going to work this afternoon. So after lunch, I'll go back a step. There was a request for replies to be made orally. I declined that reply, but thought it important that the claimants in that have the final say as such. And so after lunch, we will have the mihi. Now, in my memo, I had put in there that we would have one kaumātua or one representative from each of the tai whenua. Waihoroi, ahua rere ke te reo o Ngāpuhi ki te reo o Te Aroa. Kia mātou, ko te kotahi is one. Kia koutou rā, ko te kotahi is two. I've been given a list. If you're from Hokianga, kotahi is four. So I've been given a list of who will be speaking from each tai whenua, and I must say each tai whenua has got at least two. And as I say, some have got four, but kei te pai. We'll work with that.
But it isn't a time, it's not a time for, to be giving evidence. We've had all the evidence. It's not a time for giving the closings. We've gone through the closings. It is a time for us all to acknowledge the long journey that we've all been through. Kua pau ngā tau e iwa. You must be, I agree with Mr. Irwin, you must be getting hoha of us by now. So that's the process we'll go through, and I understand people have got the order. We'll start with our kaumātua, then the Crown, then I understand the lawyers, and then it'll be for the tai whenua. We'll go through the tai whenua. Ka pai? Kia marama? Ai marika. Ai marika. Ai marika. We'll see how much marama there was this afternoon. Kia ora tātou, we'll break for morning tea and come back at 11.